Sjean Jackson, oh, Mr. Draskovich, do you need a moment?
Oh, yeah, I'm ready.
Okay, Sjean Jackson, C 371483.
I'll stand up.
This is a -5. We're on for calendar call next week with the trial date starting the week after, but my understanding, Mr. Draskovich, is this case has been negotiated. Is that correct?
That is correct, Your Honor. The executed guilty plea agreement has been electronic.
Perfect. Did you want me to read the negotiations or do you have them? All right. It looks like Mr. Jackson is going to plead guilty to 1 count conspiracy to commit robbery, 1 count robbery, and 1 count battery with use of a deadly weapon resulting in substantial bodily harm. The state does retain the right to argue at sentencing, but will cap their argument at 6 to 15 years, Nevada Department of Corrections. All remaining counts contained in the criminal complaint, which were bound over, be dismissed when he's adjudged guilty and sentenced. State, is that all correct?
Yes, sir.
Sir, is that your understanding of the negotiations?
Yes, ma'am.
What's your true and full name?
Not for that.
How old are you?
18.
How far did you go in school?
11th grade.
So is it fair to say that you read, write, and understand the English language?
Yes, ma'am.
Are you under the influence of any alcohol,
No, ma'am.
drugs, or medication today?
No, ma'am.
Do you understand that you are being charged with conspiracy to commit robbery, and battery with use of a deadly weapon resulting in substantial bodily harm?
No, ma'am.
How do you plead to those 3 B felonies?
Guilty.
Is anybody forcing you to plead guilty?
No, ma'am.
Are you pleading guilty of your own free will?
Yes, ma'am.
All right, I'm going to go through the potential penalties for these charges. Count 1 carries 1 to 6 years, Nevada Department of Corrections, and a fine of up to $5,000. Do you understand that one is probationable? Do you understand those potential penalties? Count 2 carries 2 to 15 years, Nevada Department of Corrections. And that is potentially probationable as well. Do you understand those potential penalties? Finally, count 3 carries 2 to 15 years, Nevada Department of Corrections, fine up to $10,000 and is also probationable. Do you understand the potential penalties for count 3? Do you understand that sentencing is strictly up to the court, so nobody can promise you probation, leniency, or special treatment?
Yes, ma'am.
I have a copy of your guilty plea agreement in front of me. On page 6, your name is signed, sir. Did you sign this document?
Yes, ma'am.
Before you signed it, did you go over it with your attorney, Mr. Draskovich?
Yes, ma'am.
Did you understand this document?
Yes, ma'am.
Did your attorney answer all your questions before you signed off on this deal?
Yes, ma'am.
Did your attorney or anyone else force or threaten you in any way to make you sign off on the deal?
No, ma'am.
Do you understand that you are giving up the constitutional rights that are listed in this document by pleading guilty?
Yes, ma'am.
Do you understand that if you're not a United States citizen, this plea could result in negative immigration consequences?
Yes, ma'am.
Did you discuss your case and your rights with your attorney?
Yes, ma'am.
Do you have any questions for me regarding your case or your rights?
No, ma'am.
The 5th superseding indictment reads as follows. On or about January 12th, 2023. Count 1, defendants Simone Queen, Sjean Jackson, and Antoine McDuffie and Derek Lamont Roberts did on or about January 12th, 2023, willfully and unlawfully conspire with each other to commit a robbery by the defendants and or other conspirators committing the acts as set forth in count 2, said acts being incorporated by references both fully set forth herein. Count 2, robbery, defendants Raymond Simone Queen, Sjean Jackson, and Antoine McDuffie with Derek Lamont Roberts did on or about January 12th, 2023, willfully, unlawfully, and feloniously take personal property to wit keys from the person of Cordero Brady, knowing his presence without the consent and against the will of Cordero Brady, by means of force or violence or fear of injury immediate or future to his person, the person of a member of his family, or of anyone in his company at the time of the robbery, defendant using force or fear to obtain or retain possession of the property, prevent or overcome resistance to the taking of the property, and or to facilitate escape with use of a deadly weapon to wit, a firearm. The defendants being criminally liable under one or more of the following principles of criminal liability to wit: 1, directly committing the crime; 2, aiding or abetting in the commission of the crime with the intent that the crime be committed by counseling, encouraging, hiring, commanding, inducing, and or otherwise procuring the other to commit the crime; and or 3, pursuant to a conspiracy to commit the crime with the intent that the crime be committed. Defendants aiding or abetting and or conspiring by defendants acting in concert throughout. And then finally, count 3, battery with use of a deadly weapon resulting in substantial bodily harm. Defendants Raven Simone Queen, Sjean Jackson, and Antoine McDuffie with Derek Lamont Roberts did on or about January 12th, 2023, willfully, unlawfully, and feloniously use force or violence upon the person of another to wit Cordero Brady, with use of a deadly weapon to wit firearm, by shooting at and into the body of Cordero Brady with that firearm, resulting in substantial bodily harm to him. The defendants being criminally liable under one or more of the following principles of criminal liability to wit: 1, directly committing the crime; 2, aiding or abetting in the commission of the crime with the intent that the crime be committed by counseling, encouraging, hiring, commanding, and inducing, and or otherwise procuring the other to commit the crime; and or 3, pursuant to a conspiracy to commit the crime with the intent that the crime be committed. Defendants aiding or abetting and conspiring by defendants acting in concert throughout. And all of this occurred in Clark County. Are those the facts that cause you to plead guilty today?
Yes, ma'am.
I find there is a factual basis for the plea and it's freely and voluntarily entered. At this time, we're going to refer the case to the Department of Parole and Probation for preparation of PSI, set it down for sentencing on the following date.
That'll be June 4th at 9 a.m.
Right, so we passed that 1 week,
To June
11.
11th,
June 11th, thank you.
June 11th, 9 a.m. We'll see you back at that time. I'm going to vacate the 4:30 calendar call and the 5-6 jury trial in this matter.
Thank you.
We'll see everyone back for sentencing. Thank you. All right, pages 4 through 8. C 371483. This is going to be Raven Queen, Antonio Washington, Vince Ali, Howard Cavitt, and Lamonte Butler. All right. We see everyone present in custody. Can I have appearances for the defense?
Good morning, Tom Ericsson, Lance Mahingo on behalf of Ms. Queen, who's present in custody.
Okay,
Jeff Nicholson, on behalf of Calvin Cavitt, who was present and in custody.
Augustus Claus appearing, Your Honor, there's a substitution of counsel that was filed last night that requires a little bit of explanation, but
Okay.
I'll be appearing on behalf of Mr. Butler.
what's the explanation?
Your Honor, we filed this because we saw that there was something on the calendar this morning, but normally I insist on seeing my clients face to face, so we've had to have conversations. I wanted to have a little bit longer time to discuss things with him. I don't think there's going to be a problem with the substitution. However, Your Honor, we also have to do a deeper dive into a conflict check. While I know that I don't have a conflict with any of the named co-defendants, I haven't downloaded the witness list and done the extraordinary due diligence necessary to go through that in this case. So what I'm going to ask, Your Honor, is to pass this for, at least for my client, for 2 days for the substitution of attorney. And I think whatever was already done, I was told by the state in speaking with them that that decision was already made. However, there is a matter regarding bail that will probably need to be addressed regarding my client at some point in the very near future.
All right, so we'll see if you're going to confirm fully. We'll see what you're going to file regarding that. Additionally, before you fully sub in, I just want to let you know, ultimately, this is something that I'm hoping to get tried fairly quickly. Given that you're subbing in now affects at least 4 other people's going forward for a case that's getting older.
I've spoken with my client, Your Honor. He has no disagreement with moving the trial date, but manifestly, Your Honor, as I understand it, the trial date is set for July 5th.
I understand that might need to be moved, but I'm still hopeful that we can try this year.
Understood.
We'll address that at a further date, once you file additional motions and decide whether you're subbing in fully.
I don't need much time, Your Honor. Like I said, just 2 days to finish the due diligence.
All right, Mr. Green,
Donald Green on behalf of Mr. Washington, he is present in custody.
where's Mr. Hendrick? There you are.
Good morning, Your Honor. Lance Hendren with Mr. Lee, who's present in custody, Judge.
Okay, I'm gonna start with Ms. Queen. This is on for status check expert review on autopsy. And you guys are the number one co-defendant. Can you update us on the efforts on that, or is there another attorney? Oh, and for the record, we have Mr. Portz and Mr. Brooks for the state. Sorry. Can you update us on where we're at with that, or should I address this to another attorney?
So, Your Honor, what I can tell you is, in working with Mr. Hendren, there's a possibility that we may actually have 2 experts, but right now there's just one that we're looking at. As you're aware, I recently kind of got on this case and have now, with Mr. Mahingo taken over, that Mr. Langford's off the case. So we're kind of scrambling, trying to get everything digested and figuring out exactly where things are. But I have been speaking with Mr. Hendren. I know that they're working on that, so he can speak more as to where that expert is. But I've told them we may be getting a separate, and that is in the process of getting another expert on. Just
Okay. So I'll address that separately with Mr. Hendren as well. Obviously, you have everything after you're now lead counsel, and Mr. Mahingo is going to be your second chair.
Yes, Your Honor.
Okay, perfect. And then we are on for calendar call tomorrow, or sorry, next week on the non-homicide.
Yes, Your Honor, and I've been speaking with Mr. Portz about that. It's my understanding he's not anticipating that. What we were going to tell you, Your Honor, there's no way that we're ready to go to trial on that. So
On just the Brady matter, that one's not ready to go. So it's just the one incident.
correct, correct.
Okay,
I think there's multiple incidents on that, but yeah, we've spoken with both parties on that particular case. There's only one defendant and Miss Queen remaining in that case, so we anticipate potentially resolving the final co-defendant.
I see. And then it would be just Miss Queens potentially trailing the homicide.
I think that's the party's intent at this point.
Okay, got it. Anything else we need to address regarding Miss Queens today?
No.
Okay, moving on to Mr. Washington.
In regards to Mr. Washington, Your Honor, we are again coordinating with Mr. Hendren and now with other counsel, co-counsel concerning the autopsy reports, the review. Coordinating possibility if they get an expert looking at all that, because we too have to do our due diligence. We can tell the court that we have read or reviewed all the material. We've got a 3 gigabyte hard drive, 3 terabyte hard drive of material. There's all kinds of records and stuff. We looked at that, looked at the evidence, looked at the reviewed the grand jury and the latest grand jury, all the material which has come out. And we anticipate that if we are all together on the murder case, there's no possibility that these gentlemen, in my estimation, it wouldn't be fair to have them go to trial in July. And that's our position. We of course submit to the court.
I understand that, especially with Mr. Butler getting new counsel at this point.
Yes, ma'am.
But at this point, I'm not quite ready to address continuing it without everybody having sat down and really thought about that.
Yes.
Okay. Mr. Hendren,
Thank
keep
you.
hearing your name. What's going on?
So, Your Honor, you kind of, over the last 30 days, there's been a couple of transitions with counsel that I believe some of the attorneys are still looking over the information that they're trying to gather.
Mhm.
So they may have some different takes on how they want to proceed using a particular expert, which is fine. Just I hope it's recognized, with the transition of new counsel coming in, it kind of has for conversation purposes and providing information to, gathering all that material. If certain attorneys aren't on board anymore, then I, have to figure out then just utilizing the ones, and I believe at least right now, Mr. Duane is still on board, but I think talking with Mr. Meningo and Mr. Ericsson, again, they're still trying to go through all the material, so I'm kind of at a standstill on that.
So you have an expert retained, correct? Or you're just talking to one?
We're talking to one judge.
Okay. And then has this expert gotten the materials?
No, because what the purpose was, we were gonna, with regards to all the materials, we were gonna have a conference with the attorneys that were gonna utilize the proposed expert. But there was 2 defendants that were having transitions with new attorneys.
Okay,
That's kind of where the difficulty is coming with this judge over those last couple of weeks.
got it. All right, and then finally, Mr. Nicholson.
As to the issues concerning the autopsy report and the matters concerning the expert, we're on board with everyone along those lines, and we'll just defer to the court and the other attorneys as to what they want to do concerning the timing of it. I also have additional aspects of my defense on behalf of my client, and I have everything I needed to prepare along those lines.
Okay, regarding finally, Mr. Butler, Mr. Claus, we'll assume that you are going to sub in. If you're not going to, please alert us and we'll put it on calendar, or we'll address that further. But at this point, I'm going to do a 30-day status check on trial readiness. And at that point, if anyone is moving to continue, that would need to be addressed at that time. And at that time, I do need more progress on the expert.
Understood, Judge.
I will move forward, Your Honor, but I certainly, as a record, I hadn't received discovery from prior counsel or from the state. There was no way that I'll.
So I anticipate you'll be filing a motion to continue by that 30-day date.
Just so you're on. Additionally, there's a matter with my client's bond. I'd asked the court enter a provisional order to stop its exoneration pending my review of the file. I
Okay,
just asked you to put that in place for 14 days. If there is something that needs to be filed in that amount of time, Your Honor, I'll do it before that 14 days lapses and then readdress that with the court.
so my intent was that I was going to void the bond, so it was like it wasn't posted at all, so it would go back to him.
I would ask you to
Not do that for 14
not do
days.
that for 14 days.
Well, I mean, we've already entered all of our orders. So I guess I'll just put the minute order.
Bond hasn't been exonerated
Okay.
yet, or voided.
Okay,
Yeah, in order to readdress his custody status, Your Honor.
sure.
Obviously, with a $500,000 bond. That's a significant interest. It probably can't.
Okay, we'll stay that for 14 days if nothing has been filed at that time. we will process the voiding paperwork.
And that's
Mr. Butler remains held without bail.
Correct. Okay, we'll see everyone back in 30 days. That date will be.
That'll be May 21st at 9 AM.
The exception is Ms. Queen. We will see you next week.
Next day?
Yes, for your calendar call on the case with, it was Mr. Jackson and Mr. McDuffie.
So, and
Okay.
Your Honor,
Your Honor, I didn't mean to stick in the butt here, but could you perhaps move that just 1 week beyond that point?
Yes, please.
Sure.
That'll be May 28th.
Thank you so much, Your Honor. We started a jury trial that's been reassigned into Department 14 just the other day on the 20th, and that's been continued a couple times. The 28th is fine. Thank you
All
so
right,
much.
perfect.
you- you're, as to the trial date in May, when I've been talking with Mr. Portz, it's my understanding that he wasn't planning to go forward due to what's going on with the code of incident.
My concern is with Mr., if you're saying that Mr. McDuffie is dealt, I'd like to leave it on for that to be entered
That's fine with us.
and leave it at that time with the understanding that even if that happens, you would not be ready to go. But
Okay.
I just want to make sure Mr. McDuffie is, we're getting a decision from him.
I think that's the best route.
Okay, so we will see you next week, but you've made your record regarding not being ready to go.
Thank you.
Okay, thank you.
Thank you.
Thank you.
Thanks, everybody.
Page 11.
Page 11,